So, there was a lawsuit filed between two Florida attorneys. I believe they filed it, I think, last year. Jared Beck and his wife Elizabeth. They don't like me. I don't know why. They think I didn't cover it enough when I was at the Young Turks. I mean, I don't know how much more I could do. I was at Standing Rock and all over the country. I couldn't cover 25,000 things at once. But anyway, so they filed a lawsuit against the Democratic National Committee citing fraud because the DNC rigged the 2016 primary on behalf of Hillary Clinton, and they basically defrauded donors that had donated money. A judge tossed it out, so they appealed. And apparently, there was a follow-up on that today in a court. Blah, blah, blah. Bernie Sanders backers battle the DNC in the 11th Circuit. Again, this is the appeal. The original suit that they filed was thrown out. A group of Bernie Sanders supporters faced off against the DNC before an 11th Circuit panel Tuesday, fighting to resurrect their claims that the committee shafted them by favoring Hillary Clinton over Sanders in the 2016 presidential primary. The Sanders supporters urged the Atlanta-based Federal Appeals Court, which held hearings in Miami Tuesday, to revive a lawsuit in which they accused the DNC of shrugging off Sanders as a presidential candidate and diverting resources to help Clinton win the party's nomination for president. That's kind of not exactly what the lawsuit's about. So this is courthouse news. So their lawsuit's not because like the DNC shrug off Bernie Sanders and diverted resources to help Clinton. The lawsuit is because the DNC literally stomped the living hell out of Bernie Sanders while they were supposed to be a neutral arbiter, a neutral committee, and they didn't divert resources to help Hillary Clinton. They were a de facto arm of the Hillary Clinton campaign and literally had a joint fundraising agreement with the Hillary Clinton campaign that Politico, the leader of the establishment, Politico, literally called money laundering. So this story kind of understates what it was about. Dismissed last year in the Southern District of Florida, the lawsuit attempted to demonstrate the alleged Clinton favoritism by citing internal DNC emails which had been stolen by hackers and released on WikiLeaks. U.S. intelligence agencies have since linked the hack back to Russian agents involved in an election meddling operation. You know what I think about that, so I'm not going to bother getting into it. One of the hack documents that the Sanders supporters used as evidence in their lawsuit was a 2016 DNC memo that discusses a strategy to protect Clinton's public image while making no mention of any other candidate, according to the lawsuit. The DNC memo strongly indicates that the DNC's entire approach to the primary process was guided by the singular goal of elevating Clinton to the general election contest, the complaint states. On appeal Tuesday in the 11th Circuit, the plaintiff's attorney, Jared Beck, argued the DNC is trying to sidestep liability by portraying itself as an abstract entity without a duty to its donors. Beck reasserted one of the case's central premises, that political donors relied upon the DNC's supposed commitment to neutrality when making their donations. I think that's their core argument in the lawsuit, that political donators that donated to the DNC, to Sanders, relied on and made their donations thinking that this was a fair fight, that the DNC was really not a factor at all. They just set the debate schedule and sent out fundraising emails, and that was it. That's what people think. Or they don't think. They don't even think about the DNC, because why would you think about the DNC or the RNC when donating to a candidate? You don't expect the DNC or the RNC in the background to be working on behalf of a candidate during the primary process. You would expect them to work on behalf of a candidate after the primary process when a general election candidate has fairly won the primary. Keyword, fairly. The lawsuit seeks class certification on behalf of Sanders' campaign donors, DNC donors, and Democratic Party members in general. Counts for fraud, breach of fiduciary duty, negligence, and violations of Washington, D.C. deceptive trade code are among the causes of action. During oral arguments, U.S. Circuit Judge Alberto Adalberto Jordan seemed skeptical that certain counts in the lawsuit could proceed with respect to the Sanders donors' alleged damages. The judge said it would be a stretch to show causation between those damages and the actions of the DNC, given that the DNC is an entity separate from the organization that accepted the donations, the Sanders campaign. Judge Jordan further expressed reservations about the Sanders backers, asking the court to hold that a political party has a fiduciary duty to its donors. Quote, "You don't have any precedent in relevant jurisdictions that goes anywhere close to what you're asking us to do," Jordan told Beck. Beck, in turn, argued that in a rapidly changing post-Citizens United political landscape, where money reigns more than ever, courts nationwide need to rethink the relationship between political parties and their members. He maintained that his clients had standing to bring a federal court action, not only because they sustained financial losses, but because the stature and value of the Democratic Party, of which many of them are members, was diminished. It was an argument analogous to a securities law case in which a shareholder sues over diminishment in a company value due to a wrongful act by board members. Beck said the revelation of the alleged Clinton coddling significantly reduced the viability of the Democratic Party. DNC attorneys Bruce Spiva countered that the litigation is attempted to, quote, drag the federal court into an internal party dispute. He called the case a church fight, replete with boilerplate damage claims. And by the way, this Bruce Spiva is the same DNC attorney who basically said, legally, if we want to go in the back room, smoke some cigars, and rig it for whichever candidate we want, we could do that. That's Bruce Spiva. That's what he said last year during the initial hearing. His line of argument harkened back to the district court dismissal order last year, which tossed the case based on lack of subject matter jurisdiction. In that August 2017 dismissal order, Senior District Judge William Zlauch appeared reluctant to grant relief on matters concerning the internal workings of the Democratic Party. Quote, "Grave questions regarding the DNC's right of association would undoubtedly arise if this court were to enjoin the DNC to a particular manner of governance," the ruling states. And those same concerns would arise with respect to any award of damages, which would impose liability for the DNC's alleged decision to associate with a particular standard bearer in a matter otherwise prohibited by law. I think that the DNC fraud lawsuit, to me, I can't get into the attorneys' minds that filed it, and I'm not a lawyer, so I don't want to pretend that I'm like an expert on the law. But I think it was a good thing that it was filed, because I think that what the DNC did in 2016, they're going to try to do again in 2020. If it's Bernie, they'll probably try to do it. If it's Elizabeth Warren, I guarantee you they would do it if it was somebody like Richard Ojeda. I mean, they would do it. They don't answer to anyone, and unless, to me, the lawyers are almost serving. In this case, the lawyers are almost serving like journalists. They are sounding the alarm on a rigged process, and frankly, a money laundering process. That joint fundraising agreement between the DNC and the Hillary Clinton campaign was a money laundering scheme. It allowed the Hillary Clinton campaign to funnel money that was earmarked and supposed to go to state Democratic parties and supposed to go to the DNC. That money that was supposed to go to those entities ended up coming back to the Hillary Clinton campaign. So whether they thought they were going to win or not, as I always tell you, I think lawsuits to try and stop pipelines are always a Hail Mary, because have you ever heard of a federal judge that stopped a pipeline, especially after the pipeline has been built? You ever hear of a federal judge that made the oil company dig the pipe out of the ground? It's always a Hail Mary, because we don't live in the United States of America. We live in the United Corporations of America. But that doesn't mean that it's a bad thing to file certain lawsuits. It gets things into the public sphere. It wakes more people up that might not have tuned in to the rigged process that happened. It puts the DNC on further notice that there's a hell of a lot more eyes on you for 2019 and 20, when this rigging would go on. You're going to be under a hell of a lot more watch, not only by political activists, but lawyers. So that's the bottom line. I think it's a good thing I don't think they're going to, I'm not going to lie to you, I don't think they're going to win their appeal. Because federal judges, but basically, either judges are directly or indirectly bought off by the government too. There is a huge amount of deference that federal judges provide and give to federal governments. And also, the DNC is actually, surprisingly, it's a private company. It's not a government entity, it's a private company. So, frankly, whether it's right or wrong, in the judge's view, they could do whatever the hell they want. But I do think, again, I'm not a lawyer, so I'm just being honest. I can't speak to the law of whether the attorneys have a sound argument. I interviewed them when I was at the Young Turks. Frankly, they attacked me later on because they didn't think I was covering it enough. Whatever. But what I do think is they should keep going, and they should keep trying to publicize this. And if there's developments, I'll try to cover it as best I can. Because I think the DNC should be on notice that you cannot continue to rig these primaries. And we say rig these primaries, it's not always like rigging the voting machines. When you literally work as a public relations arm and you are planting stories in the media, you're planting stories in the media to go after a specific candidate during the primaries, which they did against Bernie Sanders. That's not neutral, and that is consumer fraud. If you're a private company and you're telling your consumers and your donors that you're a neutral body, and you are then basically working as an arm, as a public relations hitman for Hillary Clinton, or let's say it's Joe Biden coming up. I mean, Hillary Clinton's campaign invented the Bernie bro myth. The DNC helped them get it out. We saw that in the WikiLeaks emails. So all these people that say, "Oh, WikiLeaks, they hacked not whoever hacked the emails or stole the emails or leaked the emails, and these were stolen emails and a national security threat." It was all true emails that showed they were basically Hillary Clinton's campaign was coordinating with the DNC. Hillary Clinton's campaign was coordinating with the sitting president of the United States, Barack Obama. Bottom line, I think it's a good thing that they appealed. I think it's a good thing that they're keeping this out there. And I think they should honestly put them on guard that we and other lawyers and other legal observers are going to be watching your activities after in 2018, in 2019, and for 2020. They are not a government entity, so I don't think you could put in freedom of information requests to get their emails, but you can ask for emails in legal discovery if you decide to sue again, if there's reason to sue.